The next case that the court will entertain arguments on is case number 28-961, Kellie Smith versus Michael Tyler Smith. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you're going to do that, let me know and I'll keep track of time. Again, if there's any reference to children in this appeal or argument, please refer to them with initials as opposed to names. We've read the briefs and are ready to proceed if you are.
Thank you, Your Honor. May you please support, my name is Leslie Grasky, and I'm here today on behalf of Michael Tyler Smith. I would like to reserve 5 minutes, please. Thank you for your help. This matter involves people who were married for 5 years. They had they had 4 children, one born before the marriage. And it results in an agreement drafted by wife that provides for $84,000 of annual payments, which are not spousal support, which would at least give Mr. Smith the opportunity to deduct them from his income. They're not child support, which Ms. Smith would need to report to the Ohio Department of Job and Family Services, and which might interfere with the Medicaid for the children and her food stamps. And they do not seem to ever terminate. There are some of these payments which extend for 17 years until the youngest child is emancipated, but there are some that have no termination date whatsoever, which leaves the court in having denied to consider a motion for relief from judgment where $84,000 are paid by a man earning $132,000, according to the affidavit attached to the initial filing. And, excuse me, I'm sorry about the cough.
Would you like to call her?
No, that'll just make me stutter, I apologize. It has $84,000 in annual obligations that are not spousal support, not child support, and some of them are covered as property division on a marital estate that might have had $40,000 in it. There were student loan debts, there were credit card debts, there was a house, and there were some cars, and that was about it. And the court did not even consider the fact that, A, the people of the state of Ohio are providing support for these children despite the mother having $84,000 in annual payments, and that there is no allocation regarding future insurance for the children for their medical needs. It acts as a fraud against the state of Ohio and the people of the state of Ohio because it does dance around the concept that parents should be providing for their children, and that presumably a parent should not qualify for substantial aid such as Medicaid and food stamps when she has private insurance. She has her heated pool paid for. She has her mortgage paid for, her utilities, her house insurance, repair and upkeep for a 4,000 square foot home, yard maintenance, house cleaning, her car lease with no termination date, her car insurance with no termination date, $800 in college fund payments, private school tuition through high school, and if she decides to homeschool, he should pay that tuition amount to her. All expenses for the children for 17 years, Christmas money to cover the prior years, $1,500 per month to support the household, $200 per month towards an IRA for the wife, and premiums on a $2 million life insurance proceed.
Counsel?
Yes, sir.
Of course, their argument is, and the trial court found, that's what he agreed to.
It is what he agreed to, but his affidavit in support of his motion for 60B stated that it was not subject to future application because he signed this where both in the separation separation agreement and the parenting plan, it says this is based on him earning $132. And he wasn't earning $132, in part because the wife, having gotten these goodies, went to his major contract and claimed that he was stealing employees. So he lost some of his income due to the wife's interference with his contract, which is another matter, but he was not earning the sum that the agreements both say they're based on. So once the facts that the agreement is based on have changed, there's an additional reason to modify it, above and beyond the people of the state of Ohio providing so much when the wife has $84,000 tax-free in benefits.
Did you argue below that the contract is basically one against public policy or illegal?
I'm sorry.
I'm sorry, I'm not talking loud enough, and there's a lot of noise here today. I said, did you argue below that the contract is against public policy and not enforceable, or illegal and not enforceable?
I had argued that it was against public policy. I won't say that I used the words illegal. But I did raise the issue that, for one thing, it was against public policy, and for another, it was based on specific facts which no longer existed, which made it inappropriate to give that contract prospective application. Civil Rule 60B is a remedial rule, and it should be applied freely. It is not to say that Mr. Smith should have won on every single point he was raising. However, the trial court should have considered his motion for relief from judgment in light of the clear violation of statute concerning medical expenses and cash medical expenses, and upon the lack of equity in the order having prospective application. We would ask that this court remand the matter to the trial court for further consideration. Thank you.
You'll have your full 5 minutes.
Thank you.
You have 15 minutes.
Thank you. Good morning, Your Honor. My name is Cheryl Green. I'm here on behalf of Kellie Smith. First, Your Honors, Kellie argues that the first step that this court needs to take in analyzing this matter is with regard to the court's authority to even modify a separation agreement. The statute is very clear, as is the case law, that the court does not have authority to modify a property division within a separation agreement. 3105-65B specifically says that the court can maintain jurisdiction over spousal support, matters involving the children. But it specifically says it may modify property division in the separation agreement only upon the express written consent of both parties.
But you can always file 60B, can't you? Vacate, not to modify, but to vacate the whole settlement agreement.
Well, Your Honor, in Morris v. Morris, which is a Supreme Court decision, that court found that vacating an order is equivalent to modifying an order, which is governed by statute. So coming full circle back to the statute.
And I understand that argument, but I guess what I'm saying is if you find out that one of the parties completely misrepresented assets and completely committed fraud on the court and all kinds of things, you're saying there's no relief because the statute says it can't be modified?
No, Your Honor. Under 60B, I believe 1, which would govern, 3, which would govern fraud, as to the parties, then yes, 60B could be a remedy. However, in this case, there's no argument, there's no evidence that the parties defrauded each other.
Okay, so the point is then, it's not really a jurisdictional argument. It's you don't think that there is any evidence that there's a remedy under 60B here because there's no facts or nothing and no evidence to support one.
I would say it's both, Your Honor. I believe it's both. And the appellant here is arguing with regard to the affidavit by her client. If the court wants to look at the affidavit in number 5 and number 6, he specifically says that he understood it's modifiable as to support. He never indicates he thought it was modifiable as to a property division, and those are two separate and totally different things.
Counsel?
Yes,
You, I believe, accurately pointed out in your brief that these agreements are governed by contract law.
Correct.
Their contracts are governed by contract law. And people can agree to whatever they agree to.
Correct.
Isn't there a proviso there that it has to be legal? They can't agree to something illegal. Would you agree with me on that?
I would agree.
How, with that concept in mind, how do you address the Medicare, I always confuse Medicare and Medicaid, I apologize, but that aspect of the agreement?
Your Honor, I would address that as saying that it's harmless error. The cash medical provision was inadvertently omitted. There was no fraud by the officers of the court upon the court in inadvertently omitting that provision. Also, I would argue that should this court send this back, we would say that only with regard to that one provision, if that is the provision that the court is deeming to make this agreement invalid, that can be corrected without vacating or modifying the entire agreement.
But that seems like that's a critical part of the agreement.
I believe, Your Honor, it is a critical part of the agreement. However, if that agreement is vacated, also vacates the parental rights and responsibilities, because it's also in there, which the Supreme Court has said when those two things happen, and the statute says that those must be included with the dissolution, then we've restored the marriage and we've taken all the way back to the beginning, where now we're going to renegotiate property division, property that may not even exist anymore, given the time frame that we're in. And policy-wise, if every party who ever entered into a dissolution, ever entered into a separation agreement, thought that at some time that we could always come back and renegotiate that property division, then their negotiation stance might differ.
But the problem and I understand your argument, but the problem I see with that is when one of the underlying agreements or give and take is based on potentially illegal conduct. You know, you couldn't just put anything in there and just say, okay, now we can't vacate it because just of that one little area. I mean, it's all based on what their negotiation was between the two parties, and part of that negotiation was that the kids would be retained on Medicaid, which
Correct.
there's absolutely no reason why somebody should be earning $132,000 and the taxpayer should be paying Medicaid for their children. And there is absolutely no reason that I can see of that somebody should be receiving $84,000 in benefits and have their children on Medicaid. So I'm just not sure I understand that.
Well, Your Honor, with regard to the amount that the property division gives to the appellee, that's not in hard cash that she's receiving in her bank account.
But there's only, I don't know, I haven't looked at the whole record yet, and we will make sure we go through everything meticulously. But the other side is saying there's only a $40,000 estate to begin with. How do you do an $84,000 per year settlement agreement for property division based on a $40,000 estate?
And Your Honor, I would have to, I was not on this case at the trial level, I would have to defer to my co-counsel on that. I wasn't there when the negotiations happened, so I apologize, I can't answer that question.
No apology necessary.
So with that, Your Honors, we would ask that this court take into account that with regard to the affidavit, appellee is stating that without there was no hearing and therefore was also prejudiced that way. There was no operative fact that was presented in that affidavit that the court would have needed to have a hearing on with regard to any type of factual situation. We would argue, Your Honors, that vacating this entire agreement for the one inadvertent omission will open the floodgates of litigation. It will also, there would be no incentive for anyone to enter into a dissolution if they think that the agreements they make based on any harmless error or whatever might happen are going to come back years later, however many times someone decides they don't like what they agreed to anymore. And that's just, should be against public policy. So for that reason, Your Honor, we would ask that this court affirm the trial court decision and overrule the appellant's assignment of error.
Thank you. 5 minutes left for rebuttal.
Thank you, Your Honor. I think when one looks at the list of the 17 monthly payments being made by Mr. Smith according to this decree, it's pretty clear that most of those are in the nature of support. It's what we use our income from employment, child support, and spousal support to pay. It's mortgage, it's utilities, it's house insurance, it's all of the household's normal expenses. And specifically, there's $1,500 in money to support the family. So at the very least, one would think that that $1,500 could be subject to review based upon the fact that both the parenting plan and the separation agreement state that they are based upon the assumption that Mr. Smith is earning $132,000. And he was no longer doing so at the time he filed his affidavit. On its face, if someone pays their income taxes on income of $132,000, and then they pay an additional $84,000 in property division payments, there isn't enough money for that person to support themselves. And the parenting plan in this matter has very substantial provisions for what Mr. Smith is required to provide in order to have time with his children. Prior to the court ruling on P60B, Mr. Smith filed a motion in an attempt to have his parenting time with the children because on top of everything else, the mother was claiming he was not meeting the onerous provisions of the parenting plan in those regards. This agreement is so far off. If you just took 1 year of the $84,000 payments, he is paying her twice roughly the marital estate, which is contained in the affidavit for dissolution. I tried to find it on my screen and I could not, but it's clear. If it's $50,000, he's paying her more than the net estate after paying the mortgage, et cetera, et cetera. And this isn't for 1 year. This is for 17 years at the very least, and for life as to the rest. The wife is allowed to remarry, she could do almost anything, and this obligation would not be subject to review, even though it states clearly it's based on his earning $132,000. The fundamental unfairness of this decree makes it such that the trial court should have at least considered the motion for 60B so that appropriate modifications could have been made. We would ask that this court remand this matter to the trial court for further consideration. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue its decision in due course. The clerk, of course, will mail a copy of the decision of the court to each of you on the day it's released. Also, the opinions are posted on the Supreme Court of Ohio's website. Now, thank you again for your
Thanks.